are from the Bharatiya Nagarik Suraksha Sanhita BNSS. The first question is a complaint. A complaint in the Bharatiya Nagarik Suraksha Sanhita is an allegation made to a magistrate that someone has committed an offense. Complaints can be made orally or in writing. Complaint was earlier defined under Section 2D of CRPC. The same is now covered under Section 2(1)(h) of BNSS as complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this Sanhita that some person, whether known or unknown, has committed an offense but does not include a police report. Explanation: a report made by a police officer in a case which discloses after investigation the commission of a non cognizable offense shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complainant. What is a complaint in the BNSS? A complaint is an allegation made to a magistrate that someone has committed an offense. Complaints can be made orally or in writing. Complaints do not include police reports. What happens when a complaint is filed? The magistrate examines the complainant and witnesses on oath. The magistrate issues a notice to the accused, giving them the opportunity to be heard. The magistrate may take cognizance of the offense. What happens if the magistrate takes cognizance without hearing the accused? The aggrieved party can apply for a revision petition or criminal writ petition to quash the magistrate's order. Complaint was earlier defined under Section 2D of CRPC. What happens when a magistrate receives a complaint? When a magistrate receives a complaint, they are required to examine the complainant and any present witnesses under oath, recording the substance of their statements in writing, which must be signed by the complainant, witnesses, and the magistrate themselves. This process is outlined under Section 200 of the Code of Criminal Procedure to ensure the validity of the complaint before taking further action. Key points of the procedure: examination under oath. The magistrate will question the complainant and any present witnesses regarding the alleged offense, ensuring their statements are made under oath. Recording of evidence. The substance of the examination is written down and signed by all parties involved, including the magistrate. Assessment of the complaint. The magistrate will review the complaint to determine if it discloses a cognizable offense, meaning if there are sufficient grounds to proceed with the case. Possible actions based on assessment. Taking cognizance. If the magistrate finds sufficient grounds, they will take cognizance of the offense and proceed with further investigation or trial. Dismissal of the complaint. If the magistrate finds the complaint lacks merit or does not disclose a cognizable offense, they may dismiss the complaint. Further enquiry. In certain situations, the magistrate may order further enquiry to gather more information before deciding to take cognizance. Important aspects of Section 200 CRPC. Purpose. This section is designed to prevent frivolous complaints by ensuring the magistrate carefully examines the complainant and witnesses before initiating any legal proceedings. Written complaint not mandatory. While a written complaint is preferred, the magistrate can still take cognizance of an oral complaint if necessary. Transferring cases. If the magistrate deems it appropriate, they can transfer the case to another competent magistrate for further inquiry or trial. Explain the procedure of a trial before the Court of Session under BNSS. The procedure for a trial before a Court of Session under the Bharatiya Nagarik Suraksha Sanhita includes the following steps. The procedure for a trial before a Court of Session and BNSS is outlined in sections 248 to 260 of the BNSS. Here are some key sections and their details. Section 241. This section states that each offense should have a separate charge and separate trial. However, there are some exceptions to this rule as outlined in sections 242, 243, 244, 245. Framing of charges. The court reviews the evidence and allegations to determine if there is enough reason to believe the accused is guilty. If so, the court will formally charge the accused. Opening the case. Section 248. The public prosecutor explains the accusations against the accused and outlines the evidence they plan to use to prove the guilt. Evidence for the prosecution. The judge takes evidence to support the prosecution. Examination of the accused. The judge examines the accused. Hearing the defense. The accused enters their defense and presents any evidence they have. Acquittal. If the judge determines there is no evidence that the accused committed the crime, they will record an order of acquittal. The BNSS ensures that the accused rights are protected, including the right to a fair trial, legal representation, and protection against unlawful detention or coercion. Other sections related to trials before a court of session include section 248. The public prosecutor conducts the prosecution trials. Section 249. Opening the case for prosecution. Section 250. Discharge. Section 251. Framing of charge. Section 252. Conviction on plea of guilty. Section 253. Date for prosecution evidence. Section 254. Evidence for prosecution. Section 255. Acquittal. Section 256. Entering upon defense. Section 257. Arguments. Section 258. Judgment of acquittal or conviction. Concept of fair trial. The major objective of CRPC is to provide for fair trial in the administration of criminal justice. Therefore, all the provisions of the code are attuned to this goal. A fair trial refers to a legal proceeding in which all parties involved are afforded equal and just treatment, ensuring that the process is conducted impartially and without bias. The concept of fair trial is a fundamental principle in every judicial system, and this concept of fair trial ensures justice. A trial in criminal jurisprudence is a judicial examination or determination of the issues at the hands of the court to arrive at a conclusion whether the accused is guilty of the offense or not. The following elements influence in determining the fairness of a trial: presumption of innocence of accused, right of accused to have a proper defense, right to legal aid, impartial judiciary, right against self incrimination, right to speedy trial, right against double jeopardy.